What is a digital grant of probate or administration? A digital grant of probate is an electronically issued court order that confirms the person named in a deceased person's last will and testament, commonly referred to as the executor, has the required legal authority to deal with the deceased person's estate as specified in the grant. A digital grant of administration is an electronically issued court order which is required in the absence of a valid will that names a capable executor and distributes all the assets of the decedent, wherein the grant names a willing and capable applicant to act as executor and to proceed with a plan to distribute the decedent's assets, which proceeds in accordance with the jurisdiction's applicable statutes for intestacy. The digital issuance of grants is permitted by the applicable jurisdiction's surrogate rules, where legislation authorizes the court to issue grants electronically, provided that they follow the same application review process as the paper filing system. When the digital grant is issued, it is a certified court order that is in the form of a PDF document. This digital format for grants of probate and grants of administration are typically only available to practicing lawyers who undertake the legal work associated with obtaining the grant of probate or the grant of administration for their client, who is the applicant executor. Where available, it significantly streamlines the grant process and makes processing time far quicker, especially when one considers that when Canadian banks have previously advised clients as to the timeline to attain a grant, they spoke of several months, and that is without any complicating factors, which only increases the processing time. Now it is possible to attain a digital grant of probate where everyone is in agreement, including the applicant executor and the beneficiaries, in just over a week, with the lengthiest process oftentimes being the couriering of the original will to the court and its filing in the will depository prior to the issuance of the grant. This in turn translates into a far more efficient process for both the lawyer and their client, such that in those cases devoid of complexity and disputes as to inheritance, there can be a corresponding saving in legal fees, which makes the entire probate or administration process with a lawyer far more palatable, compounded by the major time saving of not having to personally undertake a paper filing with the court, which can still take months to complete, even where it is relatively straightforward. Naturally, where there is complexity and or disputable aspects related to the will or the distribution of the estate, there is going to be added legal costs involved, and they can be quite significant due to the nature of the dispute. Nevertheless, in those circumstances, it is going to be imperative that you retain the services of a lawyer, while the procedural aspects will benefit from being streamlined through the court's digital surrogate services. Digital grants of probate and digital grants of administration through the court's digital surrogate services has injected considerable efficiency into the probating and administration process with lawyers, making the entire process far more palatable for most people and significantly reducing the cost concerns that probate avoidance strategies have been harping on for far too long. If you are looking for legal services with respect to probating or administering an estate, contact our law firm for a confidential initial consultation. Thank you.